Officer Day, would you open the courtroom for me, please?
The state of Michigan 36th District Court is now in session with Honorable Judge David F. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mr. Haney.
Good morning, Your Honor.
Good morning, Counsel.
Good morning, Your Honor.
I understand you guys are here. I want to let you know that I knew you were here, but I have a couple of other things that I want to do before I get into your motion, because that's obviously going to take us quite a bit of time. So I'll put you back in the waiting room.
Thank you.
Oh, I've got Thurnblad here too. I will tell him too. You guys haven't resolved this matter, have you?
We have not.
We have not.
Okay, that's all I need to know.
All right.
That's what they pay me for.
Yep.
You know, like I tell people all the time, they don't pay me. Mr. Thurnblad?
Yes, sir.
I've got all three of you guys here on the auto owners matter, but I've got a number of other things I'm going to do before I get to you. In the meantime, you guys can always resolve your file. If not, I'll make my decision today. That's why I get paid. They don't pay me to be perfect. They pay me to make a call. The only people who get paid to be perfect in this system live in a palace of marble in Lansing. I work in a warehouse in Detroit. I'll get to you guys as soon as I can.
Thank you.
Thank you.
Thank you, Your Honor.
Bruising and steps. Good morning.
Morning, Judge. How are you today?
You're not bad for Monday. How about yourself?
Well, not bad. I opened up the court at 8:02 down at the clerk's office, you know, that special time of year.
Oh, yeah. Let's get started. This is file number 23-145-359. LVNV funding versus Erica Steps. This appears to be our third pretrial. Your appearance.
Judge, may it please the court, my name is Attorney Richard Bruson. My bar number is 35222. I'm the attorney of record for the plaintiff, and I am the attorney appearing today on behalf of the plaintiff.
And what is your name, ma'am?
My name is Erica Steps.
Okay. How are we doing on our written discovery? Are we done?
I am
Still-
done for my purposes, Judge. I served defendant by first-class mail copies of requests for admissions, interrogatories, and a production of document requests on May 25. We are now on the record on July 10th. The discovery is overdue, and frankly, I'm in the position now to file a pretrial motion for summary disposition. That I rest.
Ms. Steps, are you done with your written discovery? Are you planning on doing any?
A written discovery. I sent my response back, but a written discovery, I don't have anything to send because I'm just waiting on a contract with my signature on it.
Okay. Then what I'm going to do, if nobody has any more written discovery, your written discovery is closed. I'll give you the next pretrial date. That will be August 7th at 10 o'clock. We'll send
Okay.
you out of order. Anything else we can accomplish today?
This time, plan for us, Judge.
All right. Thank you both for coming in. We're off the record.
Thank you.
Mr. Riddell,
Good morning, Your Honor. How are you?
I'm good. Yourself?
I'm good.
What do you have?
I have LVNV versus Helen Long. It's
Okay.
case.
I think I have Mr. Kirschenheiter here on that one. Let's
Okay, that sounds right.
see if that's gonna be right. I got him on 2 cases apparently. Mr. Kirschenheiter,
Hi, Judge. How are you?
I'm not bad for Monday. Yourself?
Not too bad.
What you got?
I got two.
You got LVNV funding versus Helen Long?
I do with Mr.
Right.
Riddle.
Let's do that. I got him here. We are on the record calling file number 23146-967. LVNV funding versus Helen Long. This is our second pretrial. Could I have your appearance?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
Good morning, Your Honor. Sean Riddell, P81302, appearing on behalf of defendant Helen Long.
Gentlemen, how is our written discovery coming?
I
Your
don't.
Honor,
Yeah, go ahead, Mr. Riddle. Go ahead.
I haven't served any written discovery yet. Plaintiff's counsel has served over what would be essentially initial disclosures. We are working on an issue that I haven't had an opportunity to talk to Mr. Kirschenheiter about that may end up with cross motions for summary disposition. I believe their motion is scheduled for August 9th, and I think we would be okay with filing a motion to be heard on that date as well.
Okay, well, I have no motion for summary disposition scheduled.
Okay,
The court schedules its own motions.
right.
So what I had you guys down for my next pretrial date is August 7th. Is
That works for me as
is that gonna
well.
wait for both of you for your motions, or do you want another time?
Well, if it's up to Mr. Riddle, we filed ours, so we can have it heard whenever the court would like. But if you're filing something, Sean, if you need time, it's up to you guys.
You know what, actually, I'm wondering if after your second hearing, maybe we could step into a Zoom room and talk about the issue for a sec. But I think that the 7th would work with enough time for me to get a motion filed. And
All
tell
right,
you,
then what I will do is I will close your written discovery. I will calendar for August 7th at 10 o'clock, cross motions for summary disposition. Okay,
perfect. Thank
right
you.
now, Mr. Kirschenheiter, what is your other case?
It is 278,
And that's, who's the defendant on that?
Ralph Sewell.
I don't have Sewell as of yet. So what I'm going to do is I'm going to put you guys into the chat room. You can have your conversation. August 7th at 10 o'clock will be your cross motions for summary disposition.
Thanks, Judge.
Let's see if
Thank
I
you, Your
can
Honor.
make the technology work here. Copeland. What is Copeland for? Mr. Rusin, are you covering Mr. Varketti's motion to reopen case?
Yes, Judge, I am.
All right, I have her here. Refile. Good morning.
Good morning, Your Honor.
We are on the record calling file number 23146-354 LVNV funding versus Deborah Copeland. Date and time for plaintiff's motion to reinstate the case. Your appearances.
Judge, may it please court, my name is Attorney Richard Rusin. I am one of the attorneys for the plaintiff, attorney of record, and my bar number is 35222. Today, I'm also on your docket as the petitioner and plaintiff's motion to reinstate this civil action.
And what is your name, ma'am?
Deborah Copeland.
Ms. Copeland, did you file an answer to this motion to reinstate the case?
No, I did not.
Mr. Rusin, your motion.
Judge, may it please court, I'm going to waive oral argument and rest on my motion. And so I will rest on that. And because it appears to be an uncontested motion under MCR 2.119, I would ask that you grant the motion to reinstate the case and move the case forward. On that, I rest.
All right. No apposition having been filed in this matter, the motion to reinstate the case will be granted. The file will be set for pretrial August 7th at 10 o'clock. Your written discovery will continue. We'll send out an order today. Thank you both for coming in. We are off the record.
Thank you, Judge.
Mr. Kirschenheiter,
Hey, Judge.
were you able to settle your matter?
I think it will settle, but no, not just yet.
All right. I don't have Mr. Sewell as of yet,
Okay,
so I'll put you back in the waiting room.
sounds good. Thanks.
Mr. Cohn, good morning.
Good morning, Your Honor.
I do not have Mr. Stratton as of yet. So
Okay.
I want to let you know, I'll put you back in the waiting room.
Okay, thank you, Your Honor.
2 out of 3. Three out of 3. All right. We are on the record. This is file number 22-192503, Auto Owners Insurance. The defendants are Rescue Unit Towing, Drake's Collision. We have a motion for summary disposition filed on behalf of Rescue Unit Towing. Appearances.
Morning, Your Honor. Jared and Jessica on behalf of the plaintiff, P77599.
And good morning, Your Honor. Steve Haney on behalf of Drake's Collision, P63947.
And good morning, Your Honor. Kurt Thornblade, 25858 on behalf of Rescue Unit Towing.
Mr. Thornblade, your motion.
Thank you, Your Honor. The factual involvement of my client in this case is my client was asked to do a tow at an accident site
By the police or someone else?
by the owner.
The owner of the vehicle?
Yes, the owner of the vehicle. The police arrived later after my client had, and the owner of the vehicle informed my client that he had insurance, and the car had to be removed from the location. Because of the time, my client was not able to take it to Drake's Collision because it doesn't take cars at night. My client has its own yard where it could protect it over the night, so there were 2 tows involved. My client took the vehicle to Drake's Collision.
Now, how did it get to Drake's Collision? I didn't get that part.
Drake's Collision was the owner said, "Do you recommend a place?" And my client's driver indicated, "Well, Drake's Collision," and the owner said, "That's fine."
Okay, move on.
My client then had to store the car overnight, so my client was involved in 2 tows. My client gave the bill for the tow to Drake's Collision. They went ahead and paid my client directly, and then forwarded the bill as part of their general bill for repairs and services in this case. There are 10 different causes of action that have been pled by the plaintiff, and we asked the court to have a look at these. Court could, on our arguments, either deny our motion for a summary disposition on that particular count, could make a decision on all or some. Either would be welcome in view of the complexity that the plaintiff has inserted into this case. Counts 1 and 2 both involved conversion. Conversion has elements, and the elements are you have to take property that belongs to another, convert it to your own use. My client was under instructions from the owner of the vehicle, take my vehicle, take it to Drake's Collision. At no time did my client exercise anything more than the permission that it had been given by the owner with regard to the vehicle, and ended up surrendering the vehicle and the keys to Drake's Collision. Count 3, plaintiff says that fees are set by the motor vehicle code with regard to tows, and that is not quite correct. In the case of a police tow under contract to a police agency, there are set fees. The law in this state is that in the case of a private party tow, the fee can be whatever is set. There's nothing in the insurance contract or or anything else that just controls the fee. Counts 4, 5, and 6 all involve fraud. Fraud depends upon a misrepresentation of fact. No one associated with my client has misrepresented any fact. Now, you may say that the towing charge was too high. Perhaps there is some remedy for that in the law, but basically, when somebody performs a service, in the absence of a direct agreement as to the fee, you can ask whatever you want and argue it later. In this case, my client has already been paid, so he's out of the picture. Count 7 is unjust.
Counsel.
Yes, Your Honor.
Let's break this marathon up. Let's hear from plaintiff in regard to counts 1 and 2, common law conversion and statutory conversion.
Your Honor, there's a question of fact as to that issue, whether or not there was permission pursuant to the affidavit attached to our motion. Our
The
insured did not.
affidavit came from your adjuster.
Correct, Your Honor.
I did not see the affidavit from the driver. Did I miss that?
You did not, Your Honor.
All right. The court is going to grant motion for summary disposition as to counts 1 and 2, statutory and common law conversion. Moving on, sir, your response to count 3, the alleged violation of MCLA 257, 252. Plaintiff, it's your turn.
Sorry, Your
Remember,
Honor.
I'm breaking them up.
Yeah, my bad. As far as that one, Your Honor, that statute states that when there is a police tow, the has to be reasonable towing and storage fees. Here, I attached the call log that this was a police tow. Police arrived on the scene, and it falls under that purview. I've pled all the applicable elements of that claim, so it survives a C8 motion. And there's dispute on whether or not this was an actual police tow, and therefore there's a question of fact defeating it pursuant to MCR 2.116 C10.
Yeah. Counsel, your response to that?
No, Your Honor, it was a private contract between the driver and the owner of the vehicle and rescue unit towing.
Did I miss the affidavit in that regard?
Yes, Your Honor, that is the affidavit of my client attached.
That's
to
the affidavit of whom?
The affidavit is David Avery, who is the owner and president of
Who was
Rescue.
not at the scene.
Yes, he was. He's also the driver.
He was a driver of the tow vehicle.
Right, and he's also the president of the company.
Okay. I'm going to find that there is a question of fact in regard to count number 3, the motion for summary disposition as to count 3 is denied. Next count, we're going to hear from plaintiff in response to is count 4 and count 5, fraudulent and innocent misrepresentation.
Your Honor, that also spawns out of the fact that the insured was under the understanding that it was a police tow.
Excuse me, the insured was of the understanding or someone made a representation. But a common element in both of these is that a representation is made. At the time the representation is made, it is made and it is false at the time. Your client's understanding is not the equivalent of a representation.
Correct, Your Honor. And I guess I'm clarifying it's more as to the silent fraud count where information regarding that they were connected to the police should be disclosed and therefore not.
And that silent fraud requires an affirmative duty to disclose. What is the basis of this affirmative duty to disclose?
Your Honor, would be based on the fact that the tow truck driver was
I'm asking for a legal basis.
Okay. Your Honor, I did not. I will concede that I did not cite to that in my motion.
All right. Counts 4 and 5, fraudulent misrepresentation, innocent misrepresentation, motion for summary disposition is granted.
That would leave count 6, Your Honor, which is the silent fraud.
Whoops, I miscounted that. 4 is fraudulent misrepresentation. 5 is innocent misrepresentation.
6 is silent fraud.
6 is silent fraud, and your argument on that?
There's no duty.
No, not you.
Oh, sorry, Your Honor.
In the Honor, if I may just. Yeah.
Well, I'm so used to being in the frying pan that I have to staying on the stove.
Let me hear from plaintiff on silent fraud.
Your Honor, yeah, I just previously spoke on that. As a silent fraud, I understand that. And just for the record, I'm not asking the court to change their ruling to the fraud issue, but just for the record, the misrepresentations was that these fees were actually incurred, such as the cleanup of the accident scene itself, when the dash cam video shows it wasn't performed by the defendant. But I understand the court's ruling.
Okay, so we're down through 6. We are now going to hear argument in regard, beginning with count 7 from our moving party, Mr. Thornblake.
Your Honor, with regard to
in regard to the plaintiff's claim for enrichment, not enrichment.
Yes, Your Honor. Well, my argument with unjust enrichment is all the authority said it's an equitable cause of action and the district court lacks equitable jurisdiction.
Counsel.
Your Honor, when it's, well, unjust enrichment can be based solely on equitable jurisdiction, but also when you're seeking to enforce a contract pursuant for a money judgment, therefore that isn't within the purview of the district court.
There is no written contract here, is there? Did I miss it?
There is no written contract. It would just be an implied contract.
This is a strictly equitable request. I just lack subject matter jurisdiction here. The court finds that in regard to count number 7, unjust enrichment, I have no subject matter jurisdiction. The next the next count is violation of the Michigan Consumer Protection Act, which would be count 8. Mr. Thornblake.
Yes, Your Honor, the Michigan Consumer Protection Act does not apply between commercial parties. And that's pretty well established. And Paul versus Global Neurological Associates, it's a similar case in which an insurance company sought to assert the Michigan Consumer Protection Act in a transaction where maybe the consumer would have had a claim for under the Consumer Protection Act under statutes relating to medical release. And the Court of Appeals tells us, well, that's not the kind of transaction that's anticipated under the Michigan Consumer Protection Act. So it's the same thing. Insurance company duty to protect protect an insured against injury is not between the consumer and the person performing the service. It's between the insurance company and the person performing the service.
I'll hear from plaintiff.
Your Honor, since it's plaintiff's insured, she's an individual, and therefore it's not two businesses having a transaction. The transaction was between Ms. May Doyle and Rescue Unit Towing. Therefore, it is for personal use, and so this vehicle was insured for personal use. Therefore, it doesn't fall under the case cited of Paul v. Glendale Neurological Association, where that was a business asking and completing a transaction.
Anything else, Mr. Thornblake?
Well, the party that Mr. Andrzejewski refers to is not a party to this case. The plaintiff is the insurance company, not the owner of the vehicle.
Well, I think that I'm prepared to rule on that, and my ruling is going to be based on a slightly different ground than you gentlemen are arguing. The Michigan Consumer Protection Act doesn't regulate all interactions with consumers. The case law is quite clear that where the legislature has chosen to regulate that industry, that the Michigan Consumer Protection Act doesn't apply. An example would be, for example, insurance companies. Here, as we know under MCLA 257-252, that is the police towing casualty, although the legislature has spoken not to all aspects of the towing business, it has spoken on the towing business and has chosen to regulate only police tolls. So the court is going to say that we have an area where the legislature has regulated, but has chosen for whatever reason not to regulate the amount of non-police tolls, but that shows that there has been regulation by the state. This is not a preemption issue where the question is whether or not the action of the state fills the field. The question here is whether or not the state has elected to legislate and regulate this industry. If so, it's not falling under the Michigan Consumer Protection Act. The motion for summary disposition for counts 8, violation of the Michigan Consumer Protection Act, is granted. Count 9, civil conspiracy.
Your Honor, a civil conspiracy has to be an agreement between two or more parties to do an illegal or antisocial thing. The only agreement that can be shown here is that whenever the towing company takes a vehicle to the tow yard and the tow yard says, I'll pay your bill for you if you hand it to me and I'll send it into the insurance company, is not illegal, and it's commonly done every day.
Counsel.
Your Honor, based on the prior court's rulings as far as the fraud and conversion, since those are dismissed, those can't form the basis of a conspiracy because there's no underlying tort. And then we're down to whether or not the charging of unreasonable towing and storage fees would be a tort under this that would provide a basis for the conspiracy. It's our position that there is sufficient to form a civil conspiracy as to that count. But majority of my brief was focused on the part of conversion, which has been dismissed.
Well, the biggest problem that I have with civil conspiracy is civil conspiracy is an agreement to do a lawful thing in an unlawful way, or an agreement to do an unlawful thing and steps in that in furtherance of that agreement. I'm not seeing the unlawful agreement here. You're presuming the fact to be you bootstrapping, you're saying because I don't like to charge, it is unlawful, and therefore that makes a civil conspiracy. There's no indication here in this record, now maybe you have it from somewhere else, that there's a deal between the tow yard and the towing rescue unit. Hey, why don't you bring me tows and I'll go ahead and I'll kite up my bill and pass it on to the insurance company. That may be what you believe is happening, but there's no support for that in the record. So the court is going to grant summary disposition in regard to count 9, the civil conspiracy, which leaves us count 10, which I'm going to do without going any further. I don't have jurisdiction for declaratory relief.
And I can see that, Your Honor. I put that in my response, so that's no issue.
So let me go over in summary the ruling of the court. Counts 7 and 8 are dismissed without prejudice for the reason that the court lacks subject matter jurisdiction. The motion for summary disposition is granted as to count 1, count 2, count 4, count 5, count 6, count 8, count 9. Mr. Thornblade, I'll be looking for the order under the 7-day rule.
Thank you, Your Honor. I think count 10, I think you're dismissing without prejudice for lack of jurisdiction.
Yeah, 7 and 10 are no jurisdiction. There's no subject matter jurisdiction here. I can't do equitable things. I can't do declaratory judgments.
Okay,
Your Honor, we concurred and joined on the 22nd of May. I just wanted to make that record clear and let the court know that.
Well, I'm aware that you joined Mr. Thornblade's motion, but since his motion was about his client, what I took your motion to say is, I agree with the things Mr. Thornblade has said as to rescue towing. There was nothing that was other than your joinder that said, this is what's different, or this is what's applicable in regard to my client, the tow yard. So if you want to file something in regard to that, I'll deal with it if and when it's filed. But all I took your joinder was, I agree with Mr. Thornblad in his claims as to his client only, because there were no claims made in his motion as to your client. Likewise, the answers made by the plaintiff, which spoke to the towing company and not to the towing company and the tow yard. So that's where we are. So basically what's happening here now is we have 2 lawsuits, or two defendants. Mr. Thornblad's client has 1 claim left. Your client has 10 claims left. I would presume that from my ruling, you and counsel for plaintiff could be able to work out some of the claims that remain against your client. If not,
I would stipulate to the conspiracy, Your Honor, because you can't have a conspiracy with one party. So I'll stipulate to dismissal of that. So
I was going to make that point, but
so you guys get that together. So what's going to happen? Well, I'm going to get 2 orders here. I'm going to get a order between by plaintiff and the moving party in regard to the towing. I'm going to get a stipulated order between plaintiff and the towing storage facility as to them. Now, I'm not, for example, going to see how I'm ever going to have subject matter jurisdiction in count 7 and 10, regardless of whom the defendant is. So let it be written, so let it be done. We will next be together August 7th at 10 a.m. And
Thank
now
you, Your Honor.
that we have narrowed, at least in part, the field, we have to decide, and again, this is a business dispute. We're not curing cancer or feeding hungry children. Whether it's time to resolve this matter or you wish to continue to kill more trees. I'll see you guys August 7th at 10 o'clock. Looking forward to your 2 orders by stipulation in regard to the tow yard under the 7-day rule if you can't work it out in regard to the towing company. Anything else, gentlemen?
No, Your Honor, thank you.
One quick thing, Your Honor, may I have 7 days to perhaps kill another tree to file my motion?
I'm not limiting you. If you
Okay.
want to file your motion, you just make sure you do it before the next time we are together. So then I'll be able to calendar that too.
Thank you, Your Honor.
Okay?
Thank you.
Anything else?
Yep. Not from plaintiff, Your Honor.
Now, I must say that this is one of the cases where I'm at a disadvantage because we are virtual rather than in person. Were we in person, I would invite you 3 gentlemen to the bench, grab an ear in one hand, an ear in the other hand, and bang heads until the case was resolved. Kind of hard to do on video screen. So we'll see you guys August 7th at 10 o'clock. Thank you for coming in.
Thank you.
Thank you, Your Honor.
Have a
good day.
good day. Let's be safe
Thank
out
you.
here.
You too.
We are on the record calling file number 23-146278, Portfolio Recovery Associates versus Ralph Sewell. This is matter scheduled for a pretrial today at 10 o'clock. We were last together on this file on June 14th, 2023, at which time the parties in the court agreed to today's date, July 10th at 10 o'clock for our next pretrial. It's now after 10:30. The defendant has failed to appear. Could I have your appearance, sir?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
Mr. Kirschenheiter, you were not nice. Is that what it is? The guy didn't come?
I guess not. With defendant failing to appear, Your Honor, would ask that a default enter.
The fault will enter against the defendant who has failed to appear. No good cause having been shown.
Thank you, Your Honor. Have a great day.
You too.
Good morning, Your Honor.
Morning. We are on the record. This is file number 22-178276. Dearborn Total Automotive versus Olivia Martin. This is the date and time set. Whoops, wrong file. This is the date and time. Here. Set for pretrial by a notice dated June 14th, 2023, which was the last time that we were together. On that date, the court entered an order adjourning the plaintiff's motion for summary disposition, which was scheduled for July 10th. So, Mr. Cole, could I have your appearance?
May it please this court, Leslie Cohn appearing on behalf of the defendant, Olivia Martin.
All right, have you guys settled the case? What's going on here?
No, we still have to talk, Your Honor. We have not settled the case.
All right, then I'll have to set the date for a hearing on the motion summary disposition then.
All right, we'll presumably resolve it before then, but I would love to have been able to speak to my opposing counsel.
Well, you know, you guys, I have been holding your hands on letting this case slow walk since its inception.
I
Okay,
agree, Your Honor. I've stipulated to setting aside defaults 3 or 4 times.
he set aside a couple of defaults. He stipulated there have been a couple of instances where dispositive motions were adjourned. So, you know, you guys are just really, the fault is my own. I should not have permitted this. And I thank you for the lesson. I will not repeat this mistake again. I will set for August 7th, the motion for summary disposition at 10 o'clock. If you want to file responsive pleading, sir, you should get started on that right away.
I will. Thank you, Your Honor.
Thank you, sir.
Take care.
Be safe. Mr. Newhouse, what brings you here?
Good morning, Your Honor. I am here on Citizens versus Evans. It's a pretrial conference.
Okay, you're early for the 11 o'clock.
Yes, Your Honor.
Okay. All right, I just want to let you know I knew you were here now because I didn't see you on the docket. So we'll see you at 11.
Understood. Thank you, Your Honor.
Yes, sir. Back to the waiting room.
They have an expert, well, certainly one of the. He plays it all. what Beethoven specialist in a lot of ways. Where he was with his Beethoven movement, Beethoven's good being conservative. He's not something that he likes to get down. What is it about Fifth Symphony that really seems to get to the essence of so many composers? Beethoven, Prokofiev, Sibelius, and Shostakovich. It was kind of in hot water for an opera he composed just before the Fifth Symphony and for the Fourth Symphony, which the story goes was stopped right in the middle of the rehearsal, and it's even said that we had police didn't at one point. And we made up for it. At least we got himself back and good standing with Joe and for the Symphony No. 5, which is still a piece of music, I'm guessing. Here's the finale from Shostakovich 5 in 1909.
Hello? Hello? Hello?
I'm here.
What is,
Hello,
what is your name?
Sheila Robinson.
All right, put you back in the waiting room. Your iPhone, okay, back in the waiting room. Mr. Chisholm, good morning.
Good morning, Your Honor. How are you?
I'm good. How about yourself?
Not too bad, Judge. Thank you.
What do you have reliable finance versus homes?
That is correct, Your Honor. We met on this one not too long ago, and Mr. Holmes, we had come to an agreement. Mr. Holmes, I'm just verifying that it didn't come in since I was out on vacation last week. I just want to make sure that the consent judgment that was mailed to him hasn't been returned yet.
Okay, then we'll put you back in the waiting room. We'll move forward.
Sounds good. Thank you, Your Honor.
I don't have him as of yet.
Okay, thanks, Judge.
Morning, Judge.
Good morning. I'm waiting for Mr. Bitco to unmute and show up here. Mr. Bartholomew, good morning.
Good morning, Your Honor. Let me, I'll text Mr. Vico and see.
I'm here.
Oh, there he is.
Good morning, Your Honor.
All right, let's see if we can't get something done here. This is case number 21-170-663. Louis Bartholomew versus MJ Realty Service, PLC. Could I have your appearances, please?
Miroslav P. Volchko appearing on behalf of plaintiff Louis Bartholomew, P21851.
Mr. Donald?
Good morning, Your Honor. Robert Donald, 886 on behalf of the defendant.
The record should reflect that present but muted is plaintiff, Mr. Bartholomew. We are here today on defendant's motion for reconsideration of my denying the motion to set aside default judgment.
May I, Your Honor?
Oh, please.
So, Your Honor, this matter was, well, when we were last here, plaintiff was not here, so the court set
Plaintiff's lawyer was not here.
I'm sorry, Your Honor, plaintiff's lawyer was not here. So this matter was set over for today. And prior to our last hearing, Your Honor, defendant was not before the court because plaintiff had told the court and defendant that he was unavailable on the date that the court held the hearing, which I have included with my motion and the email where plaintiff indicated he was not available on that day and indicated to the court that he would be available sometime after May 11th and that the parties would consult and indicate to the court when that would happen. Everything after never happened. So the court held the April date where plaintiff indicated that they were not available. Defendant failed to show up and plaintiff obtained a order and obtained an order. We're asking that the court reconsider that order as pursuant to what plaintiff indicated they were unable to attend that day, and then in turn did attend that day without informing defendant, and then went on to obtain the order. When defendant reasonably, I'm sorry, Your Honor.
Donald, what is the palpable error by which the court was misled? That's what's required for reconsideration. Demonstrates palpable error which must result in reversal of decision.
The palpable error, Your Honor, is that plaintiff indicated to the court and to defendant that they were unavailable and misled the court and defendant, and defendant reasonably relied on the fact that, I'm sorry, Your Honor.
I'm a little concerned here. Maybe I'm confused, but my understanding of the way the case has been proceeding, indeed, my understanding of the way I run my docket is that I decide if there are adjournments or rescheduled. Did I enter an order saying that the April date would not proceed?
If you look at your, I'm sorry, Your Honor, if you look at the email,
is that email from the court?
No, Your Honor, not an email from an order.
The court speaks through its written orders, right?
This court speaks through its written orders, absolutely, Your Honor.
So what I had before the court was a request, not an order, a request to reschedule. The court determined not to reschedule. So how could you, in the absence of an order from the court, decide that I'm going to have my schedule dictated by counsel for the plaintiff?
And Your Honor, again, if you read the email, the court
email
responded. I'm sorry, Your Honor.
The email of whom?
The email of the court to Mr. Vico, the plaintiff.
What does it say?
The email reflected that the court would accept what the parties were going to schedule after the 11th. And I've included that email with the with my pleading, Your Honor.
Let me hear from Mr. Vico.
Yes, Your Honor. Thank you. Let me go back a little bit and correct the record from the prior statements. Both plaintiff and plaintiff's counsel appeared at the hearing on the 27th.
Yeah.
I believe earlier there was a comment that plaintiff did not appear.
No, that was not my comments, brother counsel, but please go ahead.
Well, if it's correct on the record, that's my only point. In addition, Your Honor, the court's statements are well placed. There was no adjournment made by the court that we're aware of, nor was there any court order entered to that effect. And that's why we exercised our due diligence and checked the court website, and that's why we appeared at the hearing. And it seems to me that counsel and both counsel for defendant and defendant could have done the same due diligence, which they apparently didn't do. That's our position, Your Honor.
My problem here, Mr. Donald, is that when and let's go back to the setting of the April date.
Yes, sir.
How did that happen? It happens the way all of my pretrials are set. I say, I want to do this on such and such a date. Is that date okay with each party? And everybody says yes. So this was not a date which was set without agreement of the parties. This date being set with the agreement of the parties, the court issued an order for that date.
Again, if I may, Your Honor,
Yes,
if that is not how that transpired, that date of April. So if you again read the email that the court sent on Tuesday, March 28th at 11:02 a.m., it says, I spoke with Judge Robinson. Please provide at least 2 dates next month for the appointment for your adjournment that is convenient for both counsel. Once I receive those dates, no need to appear to tomorrow's Zoom hearing.
And were those dates provided?
No, Your Honor, because again,
I'm sorry?
No, Your Honor.
Okay,
Those
so
dates
let
were
me
not.
make sure I understand this. The court provided, or should I say my court clerk said, give me 2 dates next month that are convenient with both parties. And if you do that, there will not be necessary to appear. And it is uncontroverted that the 2 dates were not provided. Have I missed something?
No, Your Honor, you are not.
So then again, as usual, I'm confused. An order setting a date agreed to by the parties. Something comes up. An email is sent, a request is made to adjourn that date, and the court's response is, give me 2 dates next month that are convenient with both parties. If that is done, it won't be necessary for the appear for the scheduled hearing.
All right.
2
and
dates
so-
never provided. 2
Yeah,
dates
so
not
then, Your
provided,
Honor,
all uncontroverted. So how do we get to a point where there's palpable error when the order had been entered with the date agreed to by all of the parties? A conditional, if you do this, you can get a new date, had been granted, and the if you do this was not done. How do we get to palpable error?
So again, Your Honor, going back to the email, so then according the plaintiff, not plaintiff's counsel, then responds and says Wednesday, April 26th and Thursday, April 27th are good dates. And then plaintiff's counsel responds and says that those are not good dates, Your Honor.
So then help me out. And once again, I'm still confused. You were made privy to communications between plaintiff and his lawyer.
I'm sorry, Your Honor.
But you were made privy to communication between plaintiff and plaintiff's lawyer. I'm still missing. I'm still missing the court being provided with 2 dates that were agreed to by the lawyers. I'm still missing that. I didn't see that.
Okay. And again, Your Honor, so that was not That was not a communication between plaintiff and plaintiff's counsel. That was a communication between plaintiff and the court.
Okay.
And then once that communication,
And then what were the dates that were provided to the court? I got it on one side.
all right, so the dates that plaintiff provided to the court was April 26th and April 27th.
And in the way we operate our litigation, who speaks for a represented plaintiff?
The lawyer.
plaintiff's lawyer.
Exactly, Your Honor. So then,
So again, I'm back to my same problem that the lawyers had been told, if you want a new date, a date different than the dates you had already agreed upon, then you got to provide 2 dates next month that are agreeable to both of y'all.
okay.
Not done. That's
I think-
uncontroversial.
All right, I think I'm understanding the disconnect, Your Honor. So, Your Honor, on March 28th, when the hearing was the next day, the March 29th date is when the hearing was going to happen. The court never got from the 2 parties a date that was acceptable pursuant to what the court says, where the 2 parties say this is acceptable.
And wasn't
So
that the
there was
condition
never,
of adjournment?
I'm sorry, Your Honor.
Wasn't getting those 2 dates from the parties for alternate dates, wasn't that the condition of the adjournment of the scheduled hearing? That's the point I'm trying to make here. I'm having trouble with your argument, sir.
Provide. All right. I'm sorry. I can read you I can read the court's email to us again, Your Honor. And it doesn't seem as if that is a condition of, it says, I spoke to Judge Robinson. Please provide at least 2 dates next month for your adjournment that is convenient for both counsels. It doesn't seem from the email, the plain reading of, I'm sorry, Your Honor.
Continue to read the email, sir.
Once I receive those dates, no need to appear to tomorrow's Zoom hearing, which was
I
the 29th.
received those dates,
I'm sorry,
it
Your Honor.
is uncontroverted. The court did not receive those 2 dates, sir.
So that means that, and I agree. It is uncontroverted.
Then
So
nothing
then
changes.
so then, I'm sorry, Your Honor.
Then nothing changed. You already
So then-
had a scheduled date. A problem arose and the court said, give me 2 dates next month that are convenient for both counsel. And if you do that, there won't be a need to appear for the hearing.
On the 29th.
Everybody agrees the 2 dates were never provided.
So
Why then
Mhm.
do you believe, in the absence of an order from the court, that the scheduled hearing was not to proceed?
The scheduled hearing was for March 29th, Your Honor. So I agree that if the 2 dates were not provided, the date that on the 28th, because the condition was not met, that 2 dates were not provided, the hearing on the 29th should have taken place, but it did not take place. Neither party appeared, Your Honor. So we are in absolute agreement on that.
Okay, so both sides agree that you disobeyed the court's order. Continue. And again, I'm still looking for my palpable error by which the court was misled. I don't understand how, in the face of a written order, failure to appear is a palpable error.
Well, again, Your Honor, so again, using the reasoning that the court has laid out for us, the hearing on the 29th should have happened because the condition preceding did not happen.
Okay.
Further, the court then sets another date pursuant to a plaintiff's email, not what the court has indicated in its email.
Okay.
And the defendant reasonably relying on what the plaintiff not plaintiffs, or I should say plaintiff's counsel, not plaintiff, saying that I can't make it on this day. And again, then if you read some more, Your Honor, up further.
Did you get an order from the court for the date when you didn't appear?
Did I get an order
from the court scheduling that date?
I did not get an order from the court to appear on the 28th, Your Honor. No, I did not. And again, that is the crux of the matter. Now, I did get an order not dismissing, but from plaintiff indicating that you had dismissed the matter and assessed costs. And I got that from plaintiff. Then I filed our motion to reconsider, which at the time when we were here last, apparently the court did not have, because then the court indicated that they didn't have an order to be reconsidered. So then the court indicated that it would draft an order, and I could then ask for that reconsideration at this date today. The palpable error, Your Honor, is plaintiff misleading the court and misleading defendant's counsel as to could they appear that date, then appearing on that date after saying they could not appear on that date. They misled the court and plaintiff's counsel, which, Your Honor, again, using the court's justifiable rationale, the date on the 29th absolutely should have happened because no dates were given. The two dates were not given on the 28th.
Mr. Brico.
Yes, sir. Yes, Your Honor. Are you asking me to reply to that?
I'm asking if there's anything else you want to tell me.
Yes, I fully agree, obviously, with the court's position. And again, no order was ever entered by the court adjourning. I think we're talking about the hearing on April 27th, aren't we, Your Honor?
That's my understanding.
That's mine also. Other counsel keeps referring to a hearing on March 29th.
Yeah, I'm
not sure what that has to do with anything.
Yeah, I'm having trouble with that.
Yeah, I'm glad you are, because I am too, Your Honor. In addition, it was clear that there was a hearing scheduled on the 27th of April, which hearing was held by the court pursuant to its original order. No order was ever given by the court to adjourn that date. And again, exercising our due diligence, Your Honor, and we weren't the moving party. It was certainly incumbent on moving party to perform due diligence and look at the court's docket online, which is what we did to make sure that the hearing was being held or whether it was adjourned. And again, we saw no order adjourning it. So that's why we performed the due diligence, because without an order, in our opinion, that hearing date stood as ordered by the court.
That's my understanding of how things work.
If I may just briefly, Your Honor.
Yes, sir.
The order issue, and I understand that while my motion is in regards to the hearing in April, the order for the hearing on the March 29th was the order that I am now saying we should have appeared on the 29th. And plaintiff's motion to adjourn that hearing on the 29th because he was unavailable is where we're at. Because on the 28th, before that order that ordered us before you on the 29th, plaintiff asked for another date. Plaintiff asked for another date. Plaintiff then failed to do what the court ordered them to do, which was to give the court 2 new dates to get another date So then the March 29th should have happened, Your Honor, because plaintiff did not do as ordered and got another date anyway.
All right.
May I have a final reply to what defendant's counsel is referring to as an order is not an order. It was an email. And the condition, as this court has pointed out repeatedly, the condition of the email was never met. Consequently, the April 27th date stood as originally scheduled. This is all pretty straightforward, Your Honor.
Yeah, the problem that we have here is that we have your client stepping out of his lane. This whole confusion is because your client improperly communicated with the court. That's not his business. He has a lawyer. That's the lawyer's job. And that's the whole problem, crux of this whole thing. And although I think it is quite clear that it was incredibly sloppy practice on the part of Mr. Donald to fail to appear for a scheduled hearing for which there was a written order in the absence of an order altering that. The fact remains that the predicate setup for this screw up was your client's doing something he ought not to have done. If your client wants to communicate with the court, then go to law school, get admitted to the bar. This is not the Gong Show. So what I'm going to do is as follows. I am going to reluctantly, because I do not like rewarding sloppy practice, Mr. Donald.
I understand, Your
Grant
Honor.
your motion for reconsideration. I am going to set the matter for a pretrial, August the 7th at 11 o'clock. Does that date and time work for everybody?
Give me 1 second, Your Honor. Let me check my calendar. You said August the 2nd?
7, August 7, excuse me.
Sorry. Thank you, Your Honor. Thanks for the correction. That date is fine with me. What time, Your Honor?
11 o'clock like today.
Okay.
Mr. Donald?
That date is fine with me, Your Honor.
All right. Well,
And
I'm sorry, go ahead. What do you want to say?
I was just going to say, just so that I'm clear, Your Honor. So the pretrial will that date, the August 7th date, will that be to argue our motions to some, because both parties had submitted a motion for summary disposition? So I just want to be clear what the pretrial date is, Your Honor. That's all.
The pretrial is to just get this file back on track.
Okay.
Because
That's fine,
we
Your
have
Honor.
a situation where, if you recall, the court had already entered a default judgment in this matter.
That is correct, Your Honor.
And when I look at the file, it looks like the last time I looked at the motion, at the default judgment, there was the motion. I didn't see motions for summary disposition. What I saw was a motion to set aside the default. What I saw
Your Honor.
was a request for a debtor's examination. Not the same thing as motion for summary disposition. And what I saw when I reviewed the register of action is the court denying on April 27th the motion to set aside the default judgment, saying that there was to be a 7-day order submitted. Then we had the supposed subpoena that was issued for May 25th for the debtor's examination. Then the motion for reconsideration was filed. Then we finally find ourselves here. So the posture, as I understand the case, is that the case is in a situation where the only thing matter to be heard is not a motion for summary disposition. It is a motion to set aside the default judgment. And I'm not understanding where this summary disposition comes from.
That's fine, Your Honor. I will address the default at our next hearing.
So this is a situation. I'm going to grant your motion to reconsider my decision not to set aside the default judgment. I will hear argument on that August 7th date to yea or nay, set aside the default judgment. If there are any further communications with the court, they will be from the lawyers only. Do we have anything else we need to resolve today, gentlemen?
Yes, one last, Your Honor. We've been, as you know, there's been a judgment entered in this case by the court, and we've been trying to schedule a creditor's exam resulting from that judgment. Can we address that issue, Your Honor?
Well, let us assume for purposes of our discussion that I decide not to set aside the default judgment in August. What will you have to do? Schedule a creditor's exam.
Correct, Your Honor.
Different by waiting until that time. And again, we have this failure to communicate because we have unauthorized contact with the court by your client. So what we're going to do is Mr. Donald is going to submit an order that is going to grant the motion for reconsideration. And in that order, he is going to schedule for August 7th at 11 o'clock, the defendant's motion to set aside the default judgment. If either of you wish to file any supplemental pleadings on the subject of setting aside the default judgment, the court will be willing to do so. It appears to me, looking at my order dated June 6th, that I had intended to set aside that judgment, but I looked like I wrote the wrong word. It looked like I wrote denied when I wrote, I should have written granted. Why would I assess attorney fees if I decided not to set aside the default judgment? But that'll be heard and decided August the 7th at 11 o'clock. The lesson, Mr. Bartholomew, you want to communicate, that's why you have a lawyer. The lesson, Mr. Donald, is that the court speaks by its written orders. The lesson, counsel, both of you, is that if you have a condition preceding to getting relief from the court and that condition preceding is not met, then the court's original order stands. Is there anything else, gentlemen?
Your Honor, I apologize. I didn't have a piece of paper to write some notes here. Would the court mind repeating its conclusion here?
The order is as follows. The motion for reconsideration is granted. On August 7th at 11 o'clock, the court will hear the motion to set aside the default judgment. If either of you wish to supplement your existing pleadings on that question, setting aside the default judgment, you may do so.
And you also said the defendant is to submit a proposed order?
No, the plaintiff, who is the moving party, is submitting the order.
I'm sorry, Your Honor. The defendant is the moving party.
The defendant is still submitting the order.
I'm sorry, Your Honor.
Defendant is submitting the order.
That's what I thought. That's what I said.
Granting the motion for reconsideration.
And setting the hearing.
Calendaring the hearing, August 7th, 2023 at 11 o'clock on the motion to set aside the default judgment. That's what any party who wishes to supplement the pleadings previously filed on the motion to set aside the default judgment may do so.
Just finishing my notes, Your Honor. Thank you for your indulgence.
Don't thank me, the taxpayers, by my time. Is there anything else, gentlemen?
Your Honor, if I may, I just wanted to take this time to apologize to the court. I misunderstood because at the time Mr. Velko was in the hospital, I wasn't sure whether he would be able to communicate with the court. I realize now that I should have reached out to Mr. Donald, who would have been able to communicate with the court. So I just wanted to apologize for that misunderstanding. It won't happen again.
Stay in your lane, Mr. Bartholomew.
Your Honor, to expand a little bit on Mr. Bartholomew's comment, both my wife and I did have a serious case of COVID, and we were either in the hospital or in a rehab facility. I don't recall which at that time, but one or the other. And Mr. Bartholomew's comment is completely accurate.
Well, I understood that there was an illness, and that was the genesis of Mr. Bartholomew's communication with the court.
Yes, exactly, Your Honor.
But the fact of the matter remains, it's an improper communication, and it's the genesis of all of our problems in this regard.
Did you ever see the movie, Your Honor, The Cool Hand Luke?
Yeah.
You know the famous line?
What we have here is a failure to communicate.
Exactly.
But it's not a failure to communicate. It's a failure to follow the rules. Those are different entirely.
Yes, Your Honor. Just to finish then, the ruling is a motion for reconsideration is granted, and the hearing is rescheduled for August 7th at 11 o'clock, and defendant's counsel is to submit an order to that effect.
Yes. And the order will also provide that either party, if they wish, not required, but may supplement their previous pleadings on the motion to set aside default judgment.
Yes, Your Honor. I'm sorry I missed that. You're correct. Of course.
Is there anything else, gentlemen?
No, Your Honor.
It's really been lovely, but I have a docket to get to.
Thank you, Your Honor. I appreciate the time. Have a great rest of the day.
Thanks. Be careful, gentlemen. Take care of yourselves.
Thank you, Your Honor.
Thank you, Your Honor.
With my order. We are on the record calling file number 211618882 Citizens Insurance versus Diana Lee Evans. We were last together on this file on, this is our first pretrial. Yeah, by a notice dated June 14th, 2023. This matter set for pretrial today, July 10th, 11 o'clock. It's now 11:39. Your appearance.
Good morning again, Your Honor. Abe Newhouse, P85687, appearing on behalf of the plaintiff.
Mr. Newhouse, looking in my waiting room, I do not have Diana Lee Evans.
Yes, Your Honor. She's failed to answer, and I believe she's failed to appear at
But she
anything.
filed an answer. That's how we set the pretrial.
She
She might not have. Oh, set the matter for you, but anyway, the default will be entered in this matter.
Does the court require a hearing date for that motion, or?
No, what's going to happen? I'm going to enter the default, and then you will submit your proposed judgment, your SCRA report, and serve all of that on the other side. And you must, of course, serve a copy of the default on the other side as well. Whoops, you know what? I count this wrong incorrectly. This should be calendared for a motion to enter a default judgment.
Right, because I believe default was already entered, Your Honor.
Oh, I see the problem. You set the matter up before Judge Coleman. Ah, I see what happened. If you notice, look at your notice of hearing. You set the file up, the matter before Judge Donald Coleman, Circuit Court Judge.
I apologize, Your Honor.
All right, so what I'll do is I will set the motion for entry of default judgment. The default has not been entered here. I opened the case to reorder. I set aside, the default was entered on April the 18th.
That's correct, Your Honor.
I remember this series of errors. So what I'm going to do is I'm going to set for August the 7th, your motion for entry of default judgment.
And will that be at 11 a.m.?
It'll be at 11 a.m. Yes, sir.
Thank you, Your Honor.
All right. All right, Mr. Newhouse, thank you.
Thank you, Your Honor. We'll get them noticed and set up that date. Thank you, Your Honor.
Bye-bye. We are on the record calling file number 22198-013, Reliable Auto Finance versus Desmond Holmes, by a notice dated June 12th, 2022. We adjourned our pretrial on this matter over to July the 18th. Whoops, let me see. That's wrong. July the 10th, excuse me. Your appearance, please.
Good morning, Your Honor. Jeremy Chisholm, P74670. I'm the attorney of record for the plaintiff.
Yeah, what's happening here? This was supposed to be settled with consent judgment and
We did, Judge, the last time we were here, Mr. Holmes and I had agreed to a consent judgment with a payment plan. And that consent judgment was mailed to him for his signature. We have not received it back yet. While I was back in the Zoom waiting room after you and I first tried to call this case this morning, Judge, I was able to check and see that Mr. Holmes did call Reliable on the 3rd of July and indicated that, by the way, the payment plan was for $130 a month to begin July 1st. He called and indicated that he was not going to be able to make his first payment until July 15th. So he is, as far as we know, he's still planning on, following through with the deal that we previously cut, but he needed a little extra time. The collector who spoke with him told him that was fine and she would note the account, and she did. And so that's where we're at, Judge, but we have not received back that consent judgment. That consent judgment was for a total amount. The prayer for relief, which was $7,597.88, along with costs, brought it to $78.12.51.
now he was supposed to pay when?
Our agreement was that he would pay $130 a month beginning July 1st of this year.
And
he
his
called on the 3rd indicating he was going to be late.
Gonna pay when?
He's now going to pay on July 15th.
On the 15th, which is a Saturday.
But I think by the 15th, Your Honor, I think is probably the more accurate way of stating
Then
that.
here's what we're gonna do. I'm gonna set this matter for hearing on July 17th.
Okay.
So either he has executed the consent judgment or we're gonna proceed otherwise. I can't just keep waiting for him to do whatever it is he's supposed to do when he feels like doing it.
Yeah, that would make up for a messy situation, Your Honor.
He's either going to return the consent judgment or he's going to appear for the pretrial. July 17th at 11 o'clock.
Sounds good, Your Honor.
And hopefully by that time, he'll have done something.
I appreciate it. And I will be here, Judge, and I'll see you next week.
All right, thank you.
All right, take care. Thank you.
Bye-bye.
Good morning, Your Honor.
Good morning. Soon as Ms. Lee comes in here, we can get started.
Okay.
Unmute and turn on video.
Okay.
All right, I think we're ready to start now. We are on the record calling file number 23240-442. Kenya Lee versus Asma Alsbury. This matter came to us by way of a removal from the general civil docket. Could I have your appearances, please?
Yes, Your Honor. Go ahead.
Kenya Lee, Your Honor.
Ma'am, I'm not hearing you.
Let me adjust my volume, Your Honor. Are you able to hear me now?
I can barely hear you. Can you speak closer to your microphone?
Yes. Are you able to hear me now, Your Honor?
I can hear you. Go ahead. You're Kenya
Okay.
Lee.
Yes, I am. Kenya Lee, the
All right,
plaintiff.
counsel, your appearance.
Good morning, Your Honor. This is Attorney Sharif McCauley on behalf of Asma Albuquerque, who is present here on Zoom.
What is your P number?
83499.
83499.
Yes.
All right. Well, let me, before I go any further, let me bring Ms. Lee up to speed here. The matter was started in the small claims division. The small claims division is very different than general civil. When a matter is started in the small claims division, either side has the right to remove the matter to general civil. In the small claims division, rules of evidence except privilege do not apply. In the small claims division, the court is not required to follow the case law or statutory law, but is to do instead, quote, substantial justice. All of that is very different where we are now. This is the general civil division. In the general civil division, the rules of evidence do apply. In the general civil division, the court must follow the court rules, must follow the statutes and the case law. So I say that to you because I want you to understand that this is now a much more formal situation than you had perhaps anticipated when you started your complaint in the small claims division. In the small claims division, lawyers are not permitted. In the general civil division, again, which is where we are now, if you want to have counsel, you have a right to retain counsel and have counsel file an appearance, just as the defendant here has done. So that's what I want to make sure you understood.
Yes, Your Honor. I actually had, after it was removed, I did obtain counsel. However, upon entering everything at the counter, my counsel did not receive anything, and so he did not file an appearance. So I don't know if at this point I could request to have the case heard when he is present. And it's
Who is the lawyer?
James Klemansky. And
all right, this is what I'm going to do. Real simple. I'm going to adjourn today's pretrial to August 7th. August 7th at 11 o'clock. Have your lawyer file the appearance. The appearance is a document by which the lawyer says he or she is in the case. Unless and until that has been filed, you are proceeding in pro per. Now, the other matter before me is what about the answer on behalf of the defendant? What's going on with that?
Did you not receive that?
I don't have it in my file here. And
we
looking,
never received it either.
looking at the
Didn't receive it, Ms. Lee?
no, looking at the register of action, the last thing that I have here is the notice of the pretrial, the removal, and then a motion. I have no.
So the answer, I emailed it as well to Brandy after I mailed it to Kenya as well. And send it again. We have till August 7th, so I can definitely resend it again. But it should be in for sure your email. But also when I sent it, I wasn't sure about that because we were having mail issues. So I made sure to email it to you as well. And I can resend to her. Let me think. The other thing is I didn't receive information for this hearing as well. So I think we're having some issues there.
You would not have received it because you hadn't filed an appearance.
Well, I filed to remove, in which I then put on there that I was her attorney. So sometimes that goes in lieu of the appearance. I can file an appearance as well.
The
request for removal?
I'm looking for it. It does not, for whatever reason, seem to have made the file. What I got was a transmitted a note from the file on the register of action saying that a removal was signed on or about June 8th. But when I look in the file, I don't see it.
Yeah,
but
so that was too at the court in person.
Yeah, okay. I see it now, but for whatever reason, did you file an answer?
Yeah, so I did file an answer and I sent it to her as well. I have it in front of me. I emailed it to your chamber. I believe I had.
If you emailed it to my chambers, the spam filter Carter, because I don't take mail. You have to go to the courts. The court has a website. When you go on the court's website, they tell you where to send it. It doesn't go to the judges.
Oh, okay, because I had spoken to your chambers and they told me to send it to that email, but I'll go ahead and do that process and what you just explained. And then I'll mail it out again. And this time I'll make sure tracked just so that we can verify that Ms. Lee receives it.
Then we'll see everybody August 7th,
And
August
also,
7th at 11 o'clock.
also, Your Honor, can I provide, since it sounds like Ms. McCauley does not have my counsel's information, which was provided when when the order was changed over, if I can provide her that information so that she can communicate directly with him, that would.
Hang on for just a second. I'm a little confused, Ms. Lee, because after I'm looking at my register of action, after you say you had communicated counsel, I see a motion filed by you.
The motion is filed in by James Clemency on behalf of me. If you look on, it's written out. It was a motion that was written out with his P number as well as his contact information.
All right, so let me get you guys.
I haven't received a motion either.
Do you have that, counsel?
No, I don't have a motion at all from them.
Okay.
I answer.
We'll see everybody August 7th at 11 o'clock. What I'm going to do is I'm going to put you guys into a chat room, and Ms. Lee, you could give her your counsel information. That might get things expedited.
Thank you, Your Honor.
Okay, let's see if I can make the technology work.
Really quick, Your Honor, can I ask a question in regards to the answer?
Please.
Will it be okay for me to edit that answer according to the motion that I haven't received? Or would you like me to hold off until the next hearing?
Hold off until we have lawyers representing the parties. We can figure out how to do things according to the court rules.
Okay.
Let me put you guys in the chat room.
Thank you, Your Honor.
Room 4. And room 4. Okay, you're both there. Is she there?
Yes, Your Honor.
You got to hit join, Ms. Lee. Here she goes. All right. Okay. We are on the record calling file number 23-149014. The file is entitled Credit Union 1 versus Sheila Robinson. Could I have your appearance, please?
Pardon me?
What is your name, ma'am?
Ben.
I'm sorry?
Sheila Robinson.
By notice dated June 14th, 2023, this matter is set for pretrial today, July 10th at 11 o'clock. It's now 11:57. Plaintiff has failed to appear. No good cause of that failure having been shown.
I'm here. I'm here.
You're the defendant, ma'am.
Oh, I thought you said in turn. I'm like, oh.
Are you?
I'm sorry.
Are you suing? Are you the plaintiff or are you the defendant?
Oh, I'm sorry. I'm the plaintiff. I'm sorry.
No, you're not. You're the defendant. You're being sued.
I'm sorry. I'm the defendant. I'm sorry. I apologize.
Plaintiff having failed to call that failure having been shown, the matter dismissed without prejudice. We'll send out an order today. Thank you for coming in, ma'am.
Thank you. I apologize.
Yes, ma'am.
Oh.
That's going to conclude our morning call.